When a lot of people think about the Indian Constitution, they kind of just imagine this dusty, static document locked away in a glass case somewhere. But honestly, that couldn't be further from the truth. Today, we're going to see how the Constitution is actually a living, breathing entity. We're going to trace a chronological journey through some of the most critical landmark judgments in Indian history, and we'll watch exactly how this document has evolved over 70 years to protect and expand our liberties. Okay, let's dive into this. Listen to this really powerful quote from Justice S. Ratnaval Pandian. He said, "The inevitable truth is that law is not static and immutable, but ever increasingly dynamic and grows with the ongoing passage of time." And I love that, because it perfectly sets the stage for our entire chronological journey today. Law has this organic element, right? It literally has to grow as society grows.
But before we start plotting out our timeline, we really need to understand what exactly we're looking at here. Professor Peter Ronald D'Souza makes this brilliant distinction. He contrasts a great judgment with a landmark judgment. So, a great judgment restores the constitutional values of a polity if it's kind of fallen astray. But a landmark judgment, that opens up entirely new directions in our constitutional thinking. It adds brand new dimensions to established principles. And today, our focus is squarely on the landmarks, the decisions that completely change the trajectory of Indian law.
So, here's our roadmap. We'll define the living Constitution, look at the strict interpretations of the 1950s, the birth of the basic structure, the emergency era, the rise of PILs, and finally, modern human rights. Let's move to it and see how this all builds over the last 70 years. Section 1, the living Constitution, a growing court. Just really quickly here, it's worth noting that just as the interpretation of the law has grown, so has the institution guarding it. The Supreme Court started with a sanctioned strength of just 8 judges, and today, that's up to 34. Section 2, early days, strict interpretations. Let's step all the way back in time to the 1950s. The Constitution is newly minted. The ink is barely dry. Look at the 1950 case of A.K. Gopalan versus State of Madras. The petitioner here challenged his preventive detention, but the Supreme Court took a very, very narrow view. They ruled that if personal liberty is taken away in accordance with the quote-unquote procedure established by law, well, then it didn't violate fundamental rights. Essentially what this meant was, as long as the state literally followed the written procedure, they could restrict your liberty. It was a very strict text-bound era. Section 3, birth of basic structure. As we transition into the 1960s and 70s, the legal landscape turns into this dramatic, high-stakes battle over who holds the ultimate power, Parliament or the Constitution. Notice the rapid chronological pendulum swing right here. In 1951, the Shankari Prasad case said Parliament has wide powers to amend, even taking away fundamental rights. But then, fast forward to 1967, the Golak-Nath case totally flipped this, ruling that the legislature does not have the power to abridge fundamental rights. This back-and-forth tension was just building and building to a massive crescendo in 1973. And that crescendo was case of Ananda Bharti. So, the crucial point is this. A historic 13-judge bench was assembled, and by a razor-thin majority of 7-6, they definitively ruled that while Parliament does have the power to amend the Constitution, it absolutely cannot alter or destroy its basic structure. The Constitution, not the Parliament, is supreme. This basic structure doctrine became the total bedrock of Indian democracy. Okay, so we've established that the basic structure protects our rights. But this raises a pretty terrifying question. What actually happens to these newfound, deeply protected fundamental rights when a national emergency is declared? Section 4, Emergency and Expanding Liberty. We now move into one of the darker periods in Indian legal history, the 1976 emergency and the powerful course corrections that followed. During the emergency, in the infamous ADM Jabapur case, a majority of the Constitution bench ruled that the right to move high courts for habeas corpus, which is essentially your right to challenge illegal detention, stood suspended. But actually, the real focus here belongs to the lone legendary dissent of Justice H.R. Khanna. He wrote that detention without trial is an anathema to all those who love personal liberty, and he noted that a dissent is an appeal to the brooding spirit of the law, to the intelligence of a future day. He lost the battle that day for sure, but he was speaking directly to the future. And you know what? That future finally answered back. Fast forward with me to 2017, in the Pataswamy case. The Supreme Court explicitly overruled that dark 1976 majority decision. The 9-judge bench stated that Justice Khanna's view must be accepted in reverence for the strength of its thoughts. Justice Sanjay Kishan Kaul famously noted the desirability of burying the ADM Jabalpur majority opinion 10 fathom deep with no chance of resurrection. Talk about a complete vindication for the brooding spirit of the law. Let's pull back to our chronological timeline for a second, right after the emergency in the late 1970s. The court realized it needed to fiercely guard liberty, so in the 1978 Maneka Gandhi case, they revisited that strict 1950s A.K. Kapalan ruling. This time, the court declared that the mere existence of a law just isn't enough to restrain personal liberty. The procedure prescribed by law cannot be arbitrary, it must be fair, just, and reasonable. The law was no longer just about checking procedural boxes, it was finally about justice. Section 5. The Rise of Pills. This newly discovered emphasis on fairness ushered in the 1980s, an era that opened the courtroom doors to the common man and the vulnerable. It really started right here, with the Mumbai Kangar Sabha case, which laid the foundation for public interest litigation, or PILs. Justice V.R. Krishna Iyer famously stated that procedural prescriptions are handmaids, not mistresses of justice. The court recognized that strict legal procedures were honestly just an added terror for the rural poor. So they allowed representative actions, meaning someone could file a case on behalf of those who couldn't afford to do it themselves. And this brilliantly illustrates how quickly that PIL mechanism was put to use. In 1978, the Sunil Batra case established that fundamental rights don't just magically flee a person when they enter prison. Then, in 1984's Banhua Mukti Morsha case, a PIL was used to actually secure the release of bonded laborers. The court affirmed that any member of the public, acting in bona fide interest, could move the court for those disabled by poverty. It was a real game changer. Section 6. Modern Era. Human Rights. And that brings us to our final chronological leap into the 2010s, a true modern renaissance for individual autonomy. Now, it might actually surprise you to know that your fundamental right to privacy was only definitively cemented just a few years ago. In the 2017 Puttaswamy case, which you might know as the Aadhaar case, the Supreme Court ruled that privacy is a constitutionally protected right, intrinsically emerging from the guarantee of life and personal liberty under Article 21. And just look at this incredible cluster of history-making judgments from this era. The court was systematically addressing questions of dignity everywhere. In 2014, the Nulsa judgment recognized transgender persons as a third gender. In 2018, Navtej Singh Johar decriminalized consensual same-sex relations, noting that Victorian morality must give way to constitutional morality. The court struck down the practice of triple talaq. In the Sabarimala case, they tackled restrictions on women's entry. And they struck down Section 497, decriminalizing adultery because the law unconstitutionally treated a husband as the master of his wife. Across all of these, the common thread is the fierce protection of individual equality and dignity. Now, what's really interesting about this slide is how far the interpretation of life has expanded. In the 2018 Common Cause judgment, the Supreme Court ruled that the right to life with dignity also includes the smoothing of the dying process. They issued guidelines for passive euthanasia, recognizing that a competent individual has the right to choose to die with dignity. To put that into perspective, the interpretation of Article 21 has grown exponentially since those super strict days of 1950. As we wrap up this massive historical arc, I want you to read this powerful reflection by Justice D.Y. Chandrachud. He notes that while some decisions are at the forefront of liberty, others must be consigned to the archives, reflective of what was, but should never have been. It's this profound acknowledgement that the court isn't perfect, but because it is a living institution interpreting a living constitution, it can self-correct. It can evolve. We've traveled a long way today, from the rigid interpretations of the 1950s, through the high-stakes battles for the basic structure, past the emergency, and into the modern triumphs of human rights. The law truly is a living thing. So I leave you with this final thought. As society keeps changing, what will be the next great constitutional question? What will be the next landmark judgment to reshape our living constitution? Stay curious, keep paying attention, because history is quite literally being written in the courtrooms every single day.